Okay, let's just dive right into this explainer. Today, we're uncovering the step-by-step process of recovering the hard-earned money that rightfully belongs to you. We're going to break down exactly how to navigate the labor board right here in North Carolina. Have you ever felt cheated by your employer when it comes to your hard-earned wages? Maybe a final paycheck mysteriously never arrived, or you noticed some sketchy, unauthorized deductions absolutely tanking your take-home pay. Well, don't worry, you are not alone in this frustrating situation, and there's an actual practical solution for this. Let's walk through exactly how you can stand up for your rights and reclaim what you're owed.
Here's our roadmap for today's explainer video. We'll hit 1. Understanding wage claims. 2. Where to file your claim. 3. Eligibility and preparation. 4. Step-by-step filing process. 5. Crucial deadlines to know. And finally, 6. Expectations, tips, and a quick disclaimer.
All right, Section 1, Understanding Wage Claims. Let's define exactly what we're dealing with.
So, what is it? A wage claim is essentially your official administrative tool to hold an employer accountable. In North Carolina, state-level requirements, things like promised wages, vacation payouts, and authorized deductions, are governed by the North Carolina Wage and Hour Act. When a boss violates these rules, filing a claim officially triggers a state investigation to go after your missing compensation.
Now, employers violate these rules in a few really common ways. They might try to cut corners by forcing off-the-clock work, totally failing to pay out promised bonuses, making unauthorized deductions from your check, or just straight-up denying accrued vacation pay, even when their own written policies say you earned it. Often these aren't just innocent little payroll glitches, they're systematic violations.
Moving right along to Section 2, Where to file your claim. This is a massive roadblock for a lot of folks.
You absolutely have to file with the right agency. Wage and hour enforcement in NC has a bit of a complex duality to it. Standard overtime and minimum wage issues, those generally go to the federal U.S. Department of Labor, the USDOL, because they fall under the Federal Fair Labor Standards Act. But state-specific issues like a withheld final paycheck, promised severance, vacation pay, or weird deductions, those are handled by the state-level North Carolina Department of Labor, or NCDOL. Filing with the wrong agency, that's going to cause severe delays, and it could literally cost you your deadlines. Building on that whole jurisdictional split, there was a major federal court decision, Figueroa v. Butterball, that basically confirmed you cannot use the state-level North Carolina Wage and Hour Act to claim standard overtime if your employer is already covered by federal law. Federal law completely preempts or overrides the state law on this. So if your issue is strictly about getting time and a half for working over 40 hours, you're almost always heading straight to the federal USDOL.
But for those promised wages, illegal deductions, and final paychecks, this is the agency you'll be working with, the North Carolina Department of Labor. Their Wage and Hour Bureau is your absolute best friend for state law claims, and they are incredibly accessible for individual workers trying to resolve these exact types of disputes.
Okay, Section 3, Eligibility and Preparation. Let's talk about what you need before you file.
First up, the $50 rule. Your disputed wage amount has to be at least $50 for the NCDOL Wage and Hour Bureau to even accept the administrative claim. If it's under $50, they just can't process it through their standard investigative channels.
You also have to get your ducks in a row with your information. Incomplete forms are just going to delay your investigation. The state needs the physical address of your employer. Absolutely no P.O. boxes allowed. You're also going to need a specific manager or HR rep they can contact, your exact rate of pay, the exact pay periods in question, and yep, even your cell phone carrier. Having your pay stubs, employment agreement, and a rock-solid calculation of what you're owed sitting right in front of you will make this process a total breeze.
Section 4, Step-by-Step Filing Process. Let's actually get this thing filed. It's a remarkably straightforward 3-step process, as long as you follow the agency's tech guidelines. The fastest method is filing directly through the online portal on the NCDOL website. Just remember, once you hit submit, your claim isn't officially filed until the agency actually reviews the data and sends you a formal confirmation email with your case identification number. Now, listen closely, because this is incredibly important. Do not use your smartphone to file the web form. The NCDOL explicitly warns that trying to complete this form on a cell phone frequently causes transmission errors or complete submission failures. Your claim could literally just disappear into a database error. Please, always use a desktop computer, a laptop, or a tablet. But hey, if you prefer talking to a real human being or you just don't have reliable computer access, you can initiate the whole process over the phone using their toll-free number, 1-800-NCA-LABOR. Their call center is fully staffed on weekdays from 8 to 4:45, and they can help you file verbally. Just make sure you have all that intake info we talked about right in front of you when you dial.
Section 5, crucial deadlines to know. Time is really not on your side here.
If your claim is about a withheld final paycheck, you have to wait exactly 10 days post-separation before you even contact the NCDOL. This mandatory 10-day cooling-off period gives your former boss a reasonable chance to just process your final pay through their normal payroll cycle. If you call on day 3, the labor board is literally just going to tell you to hang up and call back next week.
You also need to watch the administrative clock. You only have a 1-year limit for filing an NCDOL complaint. That means you have to act fast. While North Carolina law does allow a 2-year limit for a standard civil lawsuit in court, or 3 years for willful violations, the NCDOL will not accept an administrative complaint for wages that were due more than 1 year ago. Every week you delay is back pay you might permanently lose the chance to easily recover through the state agency without a lawyer.
All right, finally, Section 6, Expectations, Tips, and Disclaimer. Let's wrap this up.
So what happens next? The labor board can actually be incredibly effective. Once your case gets assigned, an investigator reviews the facts and tries to resolve it with your employer. If they bring a case on your behalf, you could get your owed wages plus interest. And get this, if the employer can't prove they acted in good faith, you might even be entitled to double damages. You just have to be patient because they handle a huge volume of complaints.
Here's a pro tip. Third-party filings are totally prohibited. A spouse, a parent, or a buddy cannot file this for you. You have to be the one to step up and assert your rights. And you can't be anonymous for standard unpaid wage claims either. You have to put your name on it so the agency can legally demand to see your specific payroll records.
Quick disclaimer time. Always remember that this explainer is strictly for educational purposes and is not formal legal advice. Every single situation is unique, right? If your case involves complex stuff like retaliation, discrimination, or independent contractor misclassification, you should absolutely consult an employment attorney for specific guidance. So, knowing your rights, the exact process, and those strict deadlines, are you ready to take action and claim the wages you rightfully earned? You worked incredibly hard for that money, so what is stopping you from going out there and getting it back? Don't let an unethical employer just keep what belongs to you. Gather your documents, check your dates, and take that first step today.